Hi, and welcome back to Perspectives. I'm Ellie Ballard, and today we're jumping into the criminal trial.
Let's start with pretrial activities. Pretrial activities include first appearance, pretrial release and bail, grand jury, the preliminary hearing, and arraignments and pleas. In the first appearance, defendants are brought before a judge and formally notified of their charges. They are advised of their rights. They're given an opportunity to retain an attorney or have one appointed to represent them if they can't afford it, and they may be afforded the opportunity for bail. The defendant is not permitted to present evidence. While the first appearance may seem similar to the arraignment, the difference is in the jurisdiction of the court. The arraignment is the first appearance before the court with the authority to try the case. Now, some states skip the first appearance and go straight to the arraignment. The first appearance may also include a probable cause hearing. Probable cause hearings are held when a defendant was arrested without a warrant. A judge reviews the police documentation to ensure there was sufficient probable cause supporting the arrest. Now, the judge is going to check to make sure, 1, a crime was committed, and 2, the defendant was the person who committed it. Now, per McNabb v. U.S., the first appearance must be held without unnecessary delay. The standard is 48 hours. If probable cause hearing is held separately, it must also be held within 48 hours. Now, this is at the federal level. States may vary. Most defendants are given the opportunity for pretrial release. 62% of state level and 66% of federal level felony defendants are released before trial. Release decisions really consider the risk of flight and the risk to public safety, and most of the decisions focus on the seriousness of the charges, the defendant's prior record, any information they have about the defendant. Are they married? Do they have a job? And are there any available supervisory options if released? For instance, electronic surveillance or probation. If a defendant is charged with a serious crime or is thought to be a danger, they can be held without bail. This is referred to as pretrial detention or remand. So let's talk about some pre-trial release mechanisms. First, we have bail. Bail serves two purposes. It helps ensure the reappearance of the defendant, and it prevents unconvicted individuals from suffering detention unnecessarily. First, we have bail bonds. This involves a cash deposit, which is posted as a pledge that the defendant will return. Fully secured bonds require that the defendant post the full amount to be set by the court. If a bail bondsman secures the bond, the defendant is typically required to pay 10 to 15% up front. And if they fail to appear, then the bail bondsman gets to keep their money. Now, there's also deposit bail, which places the role of the bondsman on the court, and the court will then collect an administrative fee. They also have property bonds. Of course, this can be like the pledge of land, a home, a car, or stocks, something to that nature as collateral. And there's also unsecured bonds. This is like credit. So you don't put any money up front, but if you fail to appear in court, they can seize whatever money or property that you may have. Now, people are also released on their own recognizance. We call it ROR. This is where the defendant just agrees to return in writing. We also can have conditional releases. This imposes conditions on the accused, such as drug treatment or community supervision. There's third-party custody. This assigns custody of the defendant to an individual or an agency, maybe like a parent or DFACS. And lastly, we have signature bonds. These are things like traffic tickets or drinking underage, petty drug violations. This is basically you get a ticket and you sign your ticket, so it's an arrest release. Grand juries originated in England during the late 12th century as a way of identifying law violators, but today we use grand juries as filters to eliminate cases without sufficient evidence. Grand juries are used in approximately half of all states. It consists of private citizens, typically 23. They're held in secret, and generally the defendant is not there. The jurors will hear evidence from only prosecutors. They also have the power to subpoena witnesses, evidence, and they can ask questions. If the majority of grand jurors agree to forward the indictment, it becomes a true bill. Preliminary hearings are used instead or in concert with grand juries. The prosecutor files a complaint against the accused, and the judge decides if there is sufficient probable cause to hold the defendant. Preliminary hearings have many of the same characteristics as a trial. A lower court summarizes the charges and reviews the rights of criminal defendants. Now, the defendant does have an opportunity to challenge the legal basis of their detention. They may actually even determine competency to stand trial, that the defendant has a rational understanding of the trial. Georgia uses both grand juries and preliminary hearings as a check and balance system against unwarranted prosecution. Now, this is the result of historical and systemic racial discrimination that has been experienced in the South. As we mentioned earlier, the arraignment is the first appearance before the court with the authority to try the case. Now, we have arraignments for two purposes. First, we inform suspects of the specific charges against them, and we allow the defendant or the suspect to enter a plea. Now, there are 4 different types of plea. Guilty, I did it. Not guilty, I didn't do it. Nolo contendere, also called no contest or nolo. It's viewed as a guilty plea. The defendant is immediately convicted and sentenced, usually to a lesser sentence. There are some benefits to a no contest plea. The plea cannot be used against the defendant in a civil trial. Defendants can also stand mute. This is typically treated as a not guilty plea. Plea bargaining is the most common way to resolve criminal cases in the United States. It accounts for almost 98% of federal convictions and 95% of state convictions. A plea bargain is the process of negotiating an agreement among the defendant, the prosecutor, and the court as to an appropriate plea and associated sentence in a given case. Plea bargaining circumvents the trial process and usually dramatically reduces the time required for the resolution of a criminal case. Now, judges do have the final say, and in having the final say, they have to first inform the defendant of the various rights that the defendant is surrendering by pleading guilty. Second, they have to determine that the plea is voluntary. And lastly, they have to make sure there's a factual basis for the plea. After a guilty plea has been entered, it may only be withdrawn with the consent of the court. Okay, let's dive into the criminal trial. Procedures in criminal trials are highly formalized, particularly concerning rules of evidence, which govern the admissibility of evidence and other procedural guidelines, all of which determine the course of the criminal trial. Now, the primary purpose of a criminal trial would be, of course, to determine the defendant's guilt or innocence. But also, it's a process that helps reaffirm society's most closely held beliefs. The stages of the criminal trial in order include pretrial activities, trial initiation. There are some speedy trial requirements we'll talk about in a second. Then we move into jury selection. Next, opening statements. First the prosecution and then the defense. There's the presentation of evidence. First the prosecution and then the defense. Then we drop down to the closing arguments. Now, the order here may vary, but typically it's the prosecution and the defense, and you'll see that the prosecution kind of gets the second bite of the apple as well. The judge makes a charge to the jury deliberates, and hopefully they return a verdict. And then the case is then moved over for sentencing or release. The Sixth Amendment guarantees that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. According to the Federal Speedy Trial Act of 1974, The prosecution must seek indictment within 30 days of an arrest, and the trial must begin within 70 days of the indictment. This can be extended to up to 180 days if the defendant or a witness cannot be called within that 70-day limit. Now, most states have enacted their own speedy trial legislation that sets limits really between 90 and 120 days. A little realized fact, though, is that often defendants waive their right to a speedy trial. This may be done for really several reasons. First, sometimes more time is needed to prepare a solid defense. Complex cases, such as those involving intricate legal issues or extensive evidence, it may require additional time for investigation, for gathering evidence and consulting with the experts. Waiving the right to a speedy trial can provide the defense with the necessary time to build a strong case. Now, in some cases, a defendant might want to delay the trial to exploit weaknesses or inconsistencies in the prosecution's case. Time can actually work in favor of the defense. It allows them to analyze the case more thoroughly. Defendants also may wish to engage in plea bargaining or negotiate for a more favorable outcome with the prosecution, and delaying the trial can give both sides more time to reach an agreement and potentially resulting in a reduced charge or a lighter sentence, or a plethora of other benefits for the defendant. Also, in some cases, crucial witnesses such as experts or key eyewitnesses may not be available on the originally scheduled trial date, so delaying the trial allows for the coordination of schedules and ensures that all necessary witnesses can testify. Evidence issues may also come up. The defendants may need extra time to challenge evidence against them, such as the legality of a search, legality of a seizure, or maybe even the admissibility of certain pieces of evidence. And waiving the right to a speedy trial can provide the defense with the opportunity to file motions and litigate these issues. Defendants may have strategic reasons for delaying their trial. For example, they may believe that a delay would weaken the prosecution's case over time as witnesses' memories fade or evidence becomes less reliable. Alternately, they may hope for changes in a legal precedent or jury attitudes that could benefit their case as well. Now, sometimes it's just a matter of health and well-being. Defendants may face health issues that make it difficult to participate effectively in their defense or attend court proceedings. So requesting a delay can allow for time for recovery or medical treatment. Now, often courts just have limited resources and busy schedules, so delaying a trial can be a practical necessity because the docket's overcrowded. And it does ensure that the case receives the attention it deserves, and it allows for a more orderly legal process. Now, while waiving the right to a speedy trial can have advantages, it also comes with risk. Delaying a trial can be seen as an admission of guilt by some, and there's no guarantee that it will always result in a more favorable outcome. Although the decision to waive the right of a speedy trial ultimately rests with the defendant, and the prosecution cannot force a waiver, prosecutors may have several reasons for wanting a defendant to waive their right to a speedy trial, depending on the circumstances of the case. Some common reasons why a prosecutor might desire such a waiver, they're going to include things like case preparation. Just like defense attorneys may need some more time to prepare their case, prosecutors may also require a little additional time to build a strong case against the defendant. This could involve gathering evidence, interviewing witnesses, and ensuring that all necessary elements are in place to secure the conviction. Now, prosecutors often engage in plea negotiations with the defendant, so waiving the right to a speedy trial can provide more time for these negotiations to take place. Defendants may be more willing to consider plea bargains as the trial date approaches, so potentially it could lead to a quicker resolution of the case. Now, just like the defense, the prosecution may have witnesses whose availability is an issue, so delaying the trial can provide some time to coordinate schedules and ensure that key witnesses are available to testify. Complex cases with intricate legal issues or a large volume of evidence, both the prosecution and the defense may benefit from additional time just to prepare. It will just result in a more fair and thorough legal process. Now, prosecutors might also have strategic reasons for seeking a delay. For example, they may want more time to address potential legal challenges raised by the defense, such as motions to suppress evidence. Delaying the trial can give the prosecution time to respond effectively. And again, there's resource constraints. Overburdened court dockets and limited resources can make it challenging to schedule trials promptly. So delaying the trial can help manage caseloads and ensure that the prosecution has adequate time to handle the case. And prosecutors may just need time to review and organize evidence. That ensures that it's presented effectively, and it's especially important in cases with large volumes of documents or digital evidence. Now, in some cases, the prosecution may just need more time to preserve and secure evidence, especially if it's perishable or subject to degradation over time. They also may just want to prepare witnesses to testify effectively in court. That can take time as well. They may need to work with witnesses to ensure that they are adequately prepared to provide testimony that supports the prosecution's case. The Sixth Amendment also guarantees the right to an impartial jury. Jurors are expected to be unbiased and free of preconceived notions about guilt or innocence. Now, to ensure impartiality, the prosecution and defense attorneys question potential jurors during the process of voir dire. During voir dire, both the prosecution and the defense can use challenges to remove prospective jurors from the jury pool. Now, let's look at some of the challenges. Challenge to the array claims that the pool from which potential jurors are to be selected is not representative of the community. Now, this is typically argued in a motion before voir dire. We have challenges for cause. This claims that a prospective juror cannot be impartial or fair. Typically, each side has an unlimited number of such challenges. In a capital case, the prosecution may want to remove a juror who's just philosophically opposed to the death penalty. Preemptory challenges. Now, these allow for the prosecution and defense to remove potential jurors without giving any reasons whatsoever. Now, typically, each side has a limited number of these types of challenges. Federal government and states, of course, vary in the number of such challenges that they would allow, but let's say, for example, in a federal capital case, each side might have 20, as many as 20 or as few as 3 in a minor case. When it can be demonstrated that an impartial jury cannot be seated, a defendant can request a change of venue. Now, the change of venue simply moves the trial to a different jurisdiction. Scientific jury selection seeks to take advantage of preemptory challenges by using social science research techniques to select members of a jury. They're trying to assess the likelihood that an individual will be predisposed to a particular outcome. This process will most likely remove someone who is very successful or highly educated. They might actually exercise too much influence over the jury. They're also going to attempt to rid the jury of any law enforcement or relatives of law enforcement. Likewise, get rid of any defense attorneys and their relatives. Also, people who are well informed. Now, some critics suggest that what's left is a composition of or undereducated, uninformed, and inexperienced persons that can be easily manipulated. Okay, we're going to do something a little bit different. We're going to continue our discussion on the criminal trial, starting with opening statements in a film on the mock trial of D.B. Cooper, starring our very own PhD candidates in the Department of Criminal Justice and Criminology. But do pay particular attention to our court reporter. She's going to be dropping lots of knowledge, so be sure to take good notes. Just real quickly, a special thanks to Alec Leverett, Anna Norman, Liv Camburn, and the amazing multimedia team at CETLO for their endless support and tireless work of bringing this project to life. Okay, that does it for me, so thank you, and as always, please reach out to your instructor if you have any questions.